Ooh, nice. All right. All right, here. Let's do an introduction. This is Dan. He's an old friend. Here, I'll have him do his introduction.
Hey, everybody. My name is Dan Roberts. I am a corporate attorney by trade. I've also got a legal tech startup that I started about 7 years ago with one of my brothers. I've worked with a lot of different types of companies, including gaming companies. I've worked also on the investor side, worked with investors. I've been a corporate attorney for 14 years. So, yeah, love working with different groups. I've worked with Cam for 6 years, maybe. What is it since?
6 years.
Yeah.
Yeah.
So, yeah, great to be here.
And we're doing a little back and forth here to make this work, but we like Dan said, he's an old friend. We've been working together. We've been in this startup space in company building for a long time. So I'm excited to have him here. All of this is going to be recorded as well. So the idea is that, we'll try to answer a lot of things, but I'm guessing a lot of things we'll go over. You'll forget whatever it is. So this will all be available after. But with that being said, I know we want to talk about a few categories. So I'm going to let Dan kind of guide this chat, make it very targeted, very valuable, and we'll answer some of your questions you guys have from the legal channel that you asked before, as well as any questions you have in the chat. So I'll pass it back to Dan.
Perfect. Thanks, Cam. Real quick, just would it be best if we answer questions as they come in, or should we kind of wait until the end?
Let's nail the first 30 minutes. Let's just go over the questions we use.
Perfect. So the kind of agenda of things that I like to talk about, this is more of like a legal 101 chat, right? This is basics of legal for folks who want to go and start a business doing whatever they may be. And I want to tailor it for people in the gaming space and be very cognizant of your specific needs. But it's going to be a pretty high level, top-down approach on legal questions that you should be aware of if you are going to be starting a company in the gaming space. So high-level agenda. First, we're going to talk about legal entity structure. So types of legal entities, how you go about forming those, things you need to be thinking about on forming your entity. That's always step one. Next up after that is ownership of your company, what we call equity. What does that look like? How do you do that? What things should you be keeping in mind when you set that company up and embark down that road? The next thing to think about are your team members, whether they're employees or contractors, what types of legal tasks need to be taken care of, and legal, issues should you be thinking about when you're bringing on team members. Last, we're going to talk about intellectual property. IP is going to be a big, important part of your company. It's what you own. That's the asset that makes you valuable. So we'll talk about intellectual property, and then we'll touch briefly on different types of customer relationships, your legal relationship with your customer. How does that play out? What governs that, and things you need to keep in mind when you do that. So if that agenda sounds good to you, Cam, I'm going to dive right in. So first item, like I talked about, entity structures. What types of entity structures are there? What can you use? What should you be using? I'm going to start out talking about U.S. entity structures. I know that there is an international, bunch of folks internationally who this might not be applicable to, and so I'll try to spin this in the international angle after I talk about how it works in the U.S. So in the U.S., there are three main types of entities, legal entities that people might use when they're forming a business. One is a C Corp. Corporation, it's taxed as a C Corp, so there's the tax structure is what we call a C Corp. So that is most commonly used for tech startups who are raising money from venture capitalists.
And you and I both,
Yeah.
I have a C Corp.
I have a C Corp. We formed it as a C Corp. There's a few tax benefits that we get as founders in the United States for forming a tech startup that is only available if you do a C Corp. So there's some benefits to the founders. And then if you're going to raise money from investors, they will only invest in a C Corp. So that's kind of a requirement. And with tech startups, that's what you're expecting to do. With other types of startups, for example, e-commerce product companies, they don't always raise money from investors, and so C Corp may not be a requirement for them. And the alternative to a C Corp in those cases is usually an LLC, limited liability company, in the United States. That is a structure that is taxed different from a C Corp. In a C Corp, the owners and the shareholders don't get taxed on the profits of the company. The company pays company level tax. Right. And then the shareholders only pay taxes if the company makes a dividend to them. In that sense, anything that the shareholders receive has actually been taxed twice because it's been taxed at the company level, and it gets taxed when it's distributed or dividended out to the shareholders.
So I'm just going to cut into the key thing here to understand is a C Corp, specifically from the negative side, is the idea that you get double taxed. Yep. Right. And so that the positive is you can raise money, you can do these things with a C Corp. The negative is double taxation. So just to put that in a simplified way.
Perfect. Thanks, Cam. So if you aren't going to be raising from investors, C Corp is a bad tax structure for you. An LLC, on the other hand, whatever the company makes, it can distribute to the owners without having to pay taxes twice. So the LLC is very nice in that regard. And so that's something that is probably going to work for you if you're not going to go raise money from investors. You probably want to target the LLC structure. The third structure, touch on briefly, is what we call an S Corp. This is a tax treatment that's very similar to an LLC, but you end up paying less self-employment tax. Again, these are tax nuances that we don't really have a lot of time to dive into, but S Corp can be very good. It's the sort of thing that you probably want to talk to your accountant and understand that the difference between an LLC and an S Corp.
And then I just want to ask, so on the S Corp, the way I have understood S Corp, right, is that you get a better taxation, but the nuance is you and your partners have to be paid out a certain amount of money in a wage. And the issue with being a game developer and doing an S Corp is oftentimes you don't make money until you release a product. And so the complexity of that entity structure, at least, and so I'd be curious to hear, is it doesn't seem to be very fitting for most game developers who are either one solo developer who incorporates long before they finish their game, right? Or, a partnership or whatever it is. That's my understanding. I don't know what your thoughts are.
Yeah, so very briefly, if you're an LLC, the owners have to pay self-employment tax in the United States, at least, on everything that they're paid out. But they don't have to have a fixed salary. So you can get paid out when you make money. Right. You'll just, however much that ends up being, you pay self-employment tax on all of it. An S Corp, you set a wage or a salary, you pay self-employment tax on that, and then everything above that, you don't pay self-employment tax on. So you're saving a lot of money in years where you make a lot of money. You're saving a lot of tax money. You don't pay taxes on it when you make a lot of money. But you have to figure that out where do you have a salary or a wage or not. So that's the complication of an S Corp. It can potentially save you a lot on taxes given the right scenario.
So I guess then if I use that understanding, then I think an S Corp would be really good if you're an individual, maybe a solo dev who waits to set up his entity until he launches his game.
That's right, yes.
Right? And so like, hey, I launched my game, you're going to have revenue, right? Then that would be a great time to then set up your S Corp, right? Which be predominantly because you've waited, now you know that you're going to be making X amount, you set your wage. So that to me seems like a solid assumption.
Yeah, absolutely. And there is a fourth option, which is the sole proprietorship, where you don't even set up a company. And there's a question in the chat about, hey, do you always need to register as a company? You don't always, but if there's multiple people, you kind of have to, because that's how multiple people can own one thing, is you join together and form a partnership, which is a limited liability company, an LLC, or a corporation. And so typically you will want to. And also, forming a company provides a shield of liability where nobody can sue you individually. They have to sue the company. And then if the company doesn't have any money, They can't come after you and your house and your spouse and your car because that company provides a liability shield to you individually. So that is why you should form a company whenever you're doing business.
Yeah, the way from my more simple non-legal brain thinks about it, it's either if you have more than one person involved in your company, set up an entity, right? It's if you have personal assets, personal stuff that you want to protect, set up an entity. And if you want to get more money or have some kind of involvement, which I think falls into the category of involvement of other people, right? You need to have an entity. You need to have a company. So I don't know if there's another simplified classification of that.
Yeah, and additionally, if you're going to be signing a contract with a bigger studio or a bigger, the App Store or wherever,
Sure.
a lot of times they're like, well, what company are you signing up under? They don't want an individual to sign up with them or to sign a contract with them or to create an account with the App Store. They're going to say, what company are you creating this account with?
Which, by the way, Steam asks for an EIN first and foremost, which is a number associated with a company, right? And so they're going to want you to be a corporation. You can use your Social Security, and I'm not sure what that is classified in other countries, right? And
your tax ID.
Your tax ID, I guess. Yeah, thank you. And so I know you can do that in other ways on Steam, but I think majority of the time they do like you being a company in general. I think any kind of App Store or Steam, like they ask for an EIN, which is your tax ID for your company. So,
yep. Now that said, you can wait if you're like developing your game, you don't know if it's going to be successful or not. Go ahead and wait, because it does cost money to form a company. So you can wait until it's launched and you realize you're going to have money coming in. Okay, go form your company, and you can have that company own what you've developed.
Yeah. I would say, like, I set up our entity for our studio because there's a group of us, and that's predominantly the reason why I set it up. But it came with issues, and so the issues are, like, I have to do taxes every year. I have to file, I don't know what the classification is, refile every single year, which costs me.
State fees. You have to pay state fees, pay an accountant to do your taxes, things like that, which it gets more complicated. There is cost associated with it. So keep that in mind. So that's kind of entity structure, forming your entity, very high level. Again, we didn't dive into the weeds a whole lot. We could talk a lot more about taxes, but we got to move on. I want to talk about some other things first. So equity.
Real quick.
Yeah.
Because I know Taco, I know a handful of you are international, and I know there's a question about Ukraine and Russia. Like, how do you deal with entity formation? Why should you be doing entity formation in the U.S.? I just would like to address that for the international.
Absolutely. So internationally, if you're not going to be raising money in the United States, it doesn't really make that much sense to form a U.S. entity just for you to run your game development out of, because you don't have any employees here, you don't have investors here. So that's the reason why you would have a U.S. company. So you can form a company in the country where you reside. Most countries have a very similar designation in terms of types of company and how they are taxed. And they also have that same liability shield for depending on what country you are in. For example, the United Kingdom and India and Australia have a very similar legal structure that they call, instead of a limited liability company, they call it a private limited. And that's the type of company that it is, but it's a pass-through taxation with liability limitations. Each company or each country will have a type of entity similar to that. I don't know every country's laws and every country's types of entities, but you should probably form your company where you are located. It's going to save you money, and it's going to be simpler. So there's going to be some education on your side to find out what makes the most sense in your country. in terms of type of entity and tax structure.
Yeah, that's good. So I know Taco, again, from the Ukraine standpoint and Russia, it sounds like if you can set it up specifically in your own country and kind of figure that out, unless you're trying to get a publisher, but I think majority of people are trying to do it on their own. I don't know if you have any context you want to give. It looks like you're typing right now, but we'll address that, and then after that we'll move on to some of the next sections. So Taco, we'll just real quick wait on that. Is there anything else you want to add while he's typing?
While Taco's typing, Rug had some comments here about, hey, do you have to do anything to make sure that there is that liability shielding between your company and your personal affairs? Yes, you want to have a company bank account and your personal bank account that you keep the money separate. If you have all of the money coming into your personal bank account that is made from your company, a judge that looks at that is going to say, you're basically the same thing. You're treating it the same way. Why should we treat it different? So you want to treat it as a separate legal existence from yourself by having a separate bank account, having a separate credit card, having company expenses paid from your company credit card rather than your personal credit card. Or if you pay it from your personal credit card, you do some documentation to show the company is reimbursing you for that expense because it's a company expense, not a personal expense. So that's, what you want to think about. Downsides, for Judith, to having a company as a solo developer, additional costs, as Cam mentioned. That's the biggest downside, is it costs money and head space and, time. All right. Interesting.
Interesting, Taco.
Yeah, I don't know Ukraine or Russian, state law in terms of entity formations, so I can't help out with what the best route there would be. Ab, do we want to look at what Ab's going here?
Yeah, here. I guess, you look at Ab's real quick. And so I think, I don't know, right, from a legal standpoint when it's wartime. I don't know if there is. I think you do your best with what you have. I think it's the nature of how do you protect any kind of legal stuff when legal kind of goes out the door. And so I just want to address that. It's like I think the best thing you can do is, do you trust these people? Do your best to set up a legal structure with what you can. Putting the ownership of what you're building underneath that legal structure would be my assumption. And then, do your best within those parameters. I don't know how you can, again, if there's no protection of legal, there's wartime. I don't know how much a legal entity can and will protect you. So that's going to be my own 2 cents. I don't know if you want to add anything else before we address apps, but
no, I think that's great advice, Cam. And good luck, Taco. That's kind of a tough regime to be working out of. So we definitely wish the best of luck. I think most of Ab's questions are very much IP related. Okay. I want to touch on some of these questions about, hey, Creative Commons or copyright and using other games as references, things like that in some of our other items that we hit. Perfect. Before we get to IP, so owning your company. If you're a solo owner, you don't really need to worry about it. You just own your company, you form it and list yourself as the sole member or stockholder or partner or owner, depending on what it is, what nomenclature you use in that entity. And you're good. You own 100% of your company. If you've got a team, you need to make sure that you issue ownership officially and legally the way that it needs to be done. In the United States with an LLC, you have an operating agreement for your company, and in that operating agreement, it should say when you issue new ownership to somebody, it has to be approved by whoever is doing the approving, the governance of your company. And that governance, usually the way I set up companies is there's a manager who can approve things like issuing ownership to new people. So you just need to make sure that you follow the right procedure to issuing ownership to additional team members or founders, co-founders, partners, whoever it may be. If you're doing a tech startup, it can get a lot more complicated. There are things like stock options, preferred stock, convertible notes. There's a lot of different things that we go down when we're raising money or bringing on team members in a corporation that you don't really need to worry about if you're not going to be having a huge team with investors that need special rights. If it's just you and a few partners, just figure out what percentage everybody's going to get. My one thing that I would recommend here is that when you issue ownership to somebody, you have an actual legal document, and in that document, you include what I call a vesting schedule. What a vesting schedule does is it basically says, as everybody continues to work for the company, that ownership that they've been given, if it's 10%, 20%, 50%, it vests over time as they continue to work for the company. And that way, if somebody leaves after you give them that ownership chunk, that percentage of the company, you can get it back from them because they haven't vested into the ownership. And so vesting schedules protect you as the main founder from somebody leaving and taking a chunk of your company or a percentage of your company with them.
So just to add any context, the way I understand it and the way I think targeting game developers, majority of the time, you're not going to raise money in the normal terms. You're probably not going to issue stock options. Like, again, we both have done startups and software, have raised money. But in this context, specifically, what you just need to understand is you most likely have a few partners. You're making a game with a few people. You just want to figure out who should have ownership of what, right? Johnny has 10%. Billy has 50, right? Miranda has 40, whatever it is. But the idea is, like, what if Miranda a year from now leaves and she has 40% of the company? So what he's saying is a vesting schedule is purely meant to just help you kind of protect you and protect your company so that the people kind of that are serious, they stay, so that the ownership of the company stays and that everyone, and you can change it, right? Like, the idea Absolutely. Is that you can change, like, I could have 40% now, but maybe 20% later because I'm not putting in the work. I don't know.
Yeah, no, you can definitely change it, and you can issue somebody more money, more ownership, more equity, as things go along, and you figure out what the right ownership should be. As people contribute more or less, you might want to change that. And so, as long as your company is set up the right way, that governance structure it allows you as the main founder to make those decisions.
And just to give a plug, like, if you guys are like, how in the world do I do this, right? The idea is, with that going into GameKit, the thing that we're building, we're actually partnering with Dan and their team over at Savvy so that you guys can be able to do that for a really low cost. And so that's like, you're like, great, sounds great. How do I do it? Well, that's going to be the ideas with the product that we're building. A lot of you guys that were part of our game jam will get access to our toolkit for free, and some free tools will be coming from them. And so, anyways, so just wanted to let you know, if you're like, how in the world, Dan is very kindly actually putting up a lot of work and effort to help you guys out. So that'll be coming soon.
Perfect. Thanks, Cam. So that's kind of the high level for ownership. Just want to make sure you guys are thinking about that in the right way and realizing that it is a very important. You do not, the worst thing that can happen to you as a primary founder is that you get to the point where your game is successful, and then your team comes and says, well, I'm pretty sure you told me that I would own 50% of this thing, when in reality that was never the intent. It wasn't ever discussed. But because you don't have anything documented, somebody's taking advantage of you, because now there's dollar signs in everybody's eyes. So document everything legally, make sure that it's done right from the get-go. Right after you have that conversation, get a document signed so that nobody can say, oh, that's not what we agreed to. That's very important. Ownership has the potential to really ruin your financials down the road as you start realizing that your company is going to be a huge success, but you didn't document ownership the right way. That's a big money, it's a problem. So that's, keep that in mind. There's a reason why I mentioned it second, because it is something you got to get done right out the gate. Ownership of the company. Next type of legal things you should be thinking about and being aware of: your team. Who is helping you? Who's working with on your project? What are they doing? We want to make sure that anybody who is part of your team, whether they are employees, which you probably won't have employees right out the gate, but thinking ahead, are you going to have employees? Contractors who are going to be contributing just small pieces to what you do on a contract basis. Those are contractors. That's your team. And so what are the things you need to be thinking about in terms of, hey, what legal do I need in place before I bring on team members? The most important thing for you is what we call IP assignment. Now, IP, it means intellectual property. Intellectual property, and we're going to talk about intellectual property in a little bit, but it's basically your code, your art, your designs. That is all intellectual property, and that can all be coming from outside third-party contractors, your partners who might be employees or just co-founders. It can be coming from a lot of different directions, and you want to make sure that your company owns all of the IP that anybody works on. In a lot of countries, the default rule is that if somebody works on a project, whether that is creating art, writing code, doing videos, any of that, the person who creates the content owns it. So that means your company does not own it unless you have a contract in place where that contractor who created the content has assigned it to your company. So if you are going and having people work on your game, again, whether it's music, art, code, videos, audio, whatever it may be, if you don't have a contract in place that specifically says this work product and intellectual property is assigned to and owned by the company, then you don't own it, and that means you don't own your game. You don't own parts of your game that they worked on, and that is a big problem for you. If, again, you get to the point where your game is successful, this person can come to you and say, hey, great job on creating that successful game, putting it all together. I contributed this, and I never assigned it to you, which means I own 10% of whatever you just made from your game. Or they could make a claim that they own 50% or 80%. Like, they can make whatever claim they want, and because you didn't get a contract in place with that person that assigned the IP that they worked on to your company, they might win in a legal battle. At the very least, you might have to settle with them and pay them a big chunk of money to get ownership from them at that point that you wouldn't have had to pay if you just got them to sign an IP assignment contract. And this is usually just a standard provision in a contractor agreement. I call my contractor agreements independent contractor agreements because it's a signal that they are independent of the company. But that contractor agreement needs to have kind of three things. One, IP assignment. Two, confidentiality, which means they're not going to take your designs, whatever they're building for you, and share them with another game company. You want to keep what they're working on confidential. So confidentiality is a part of that contractor agreement. And the last piece is very clear, like, hey, this is what you're delivering and this is what I'm paying you. Last thing you want is for somebody to deliver a work product to you and then come back and say, well, you promised me X amount per hour, and it took me 5 million hours. You know, that you don't want somebody to be able to take advantage of you after you're successful. So that's the point of a contract. So very clear deliverables and what you're paying for those deliverables. So that's the contractor agreements. Employees, very similar. You want to make sure that they sign IP assignment and confidentiality. You might be able to get some other things in there with employees, but those are the main things that I like to see from any team member, whether they're an employee or a contractor.
So most of you guys aren't probably going to have employees. What you will have are a lot of contractors or partners, right? I think in the majority of these cases, it's, hey, you two friends came together to make this game, or you're doing it alone. You realize you're not very good at art, right? So you pay somebody else. That's what, I'm a prime example of that. So with that being said, no matter, even if you trust them, like some of the people I've done work with for a long time. Again, Dan and I have been working together for many years. Even though we're great friends, we would still do contracts, right? And so it doesn't matter who you know and if you trust them. All my partners, people I've worked with for 10 years, people I know for a long time, it's more out of it's respect. I feel like it's just how business should be done, and you shouldn't view it in any kind of disrespect to go to your friend or go to your partner and say, hey, let's put this in a contract. So I want to make sure that was crystal clear.
Perfect. Yeah, and again, doesn't matter who it is. Might be your brother, might be your mom. Have them sign a legal contract with the company.
I know brothers, I know dads and sons that have gone to war in legal, in court, fighting over stuff. And so I don't know.
Always sign a contract at the outset when you're first getting started, just to make sure that it's clear what everybody's doing and who owns what.
Protects relationships.
It protects relationships. So that's your team members. Again, reiterate, IP assignment, confidentiality, that's what you want to focus on with all team members. No exceptions. And to Cam's point, we have standard contractor agreements and IP assignment kind of workflows with templates that folks can use on our platform that Cam's going to be making available through the game kit.
Yeah, so here. So just, again, for those that maybe weren't here, just to reiterate, part of that product that we're building together for you guys, for game developers, is to help with each of these things, from entity that we talked about at the beginning, to equity, which was kind of assigning who owns what, to even what we would classify this section as IP ownership. Yep. So there's going to be stuff on each of these things that help you guys out.
Perfect. So let's dive into intellectual property. This is a very important piece for you guys because this is where the value of your company lives. You guys aren't building, bridges, the physical structures. You're not, creating clothes that you're selling. Like, the asset of your company is the intellectual property of your company, the IP. So what are the different types of IP that your company might have? So when we talk about IP, there's 3 general classifications. One of them is patents, which probably doesn't apply to you guys. Patents are not going to be something, you can't really patent a game idea, a game structure. You can't.
Do you guys have any patents?
We do not own patents. We're a tech company.
We own patents.
So Cam owns patents.
It does nothing. I have a software company with patents, the biggest waste of money, by the way.
It is. I actually was looking at becoming a patent attorney at one point. If Cam would have asked me, and he may have asked me, I would have told him patents probably aren't going to be worth the money that you pay as a software company. Games are a software company, a version of a software company. Patents can't really protect software. What does protect software is copyright. Now, patents are something that you have to file. You don't own a patent unless you file it. A copyright is something that any creator owns as soon as they create something. That can be written word. If you're writing a book, writing dialogue, the written word is copyrighted. Automatically, you have that protection as soon as you put pen to paper. Nobody can plagiarize that, or else you can sue them. Art is copyrighted. There's copyright protection on art. You own the copyright of your art without having to file anything. Nobody can copy your art. Same with code. Code is considered an artistic creation, just like writing a book is. So your code or somebody else's code is protected by copyright. You cannot steal somebody's code. You can't copy it without a license. So what this means to you guys, and video is the same way, photography, all of this is copyright protection. So copyright law in the United States states that whoever the creator is owns the copyright unless they have assigned it. And that assignment, we've talked about that with that contractor agreement, that IP assignment. That's how you get the assignment assigned to your company. You have that contractor agreement. That's why we talked about the contractor agreement first, because IP assignment makes sure you own the copyright for the code, the art, the audio, the visual, whatever it is for your game. There's a specific language in the Copyright Act of the United States called that you want to have in that contract, and that's a big part of why you want a good template to draft that contract, rather than having AI go and draft it for you. AI probably isn't going to realize that the Copyright Act of the United States requires this specific phrase, which is work made for hire. You want that phrase, and I even put it in quotation marks. I say, this is work made for hire as set forth in the U.S. Copyright Act. So I specifically call out that we have this phrase, and that way the copyright is assigned to the company. AI-generated contract probably isn't going to realize you need that clause. They're going to go and draft you up some good language, but it might not comply with the U.S. Copyright Act.
I didn't know that.
So that is something to keep in mind with copyright, and when you're having those contractors sign that agreement. You want to own your copyright for what the contractors do. A couple other things to keep in mind with copyright, and this came up with something that Ab mentioned. There are tools out there, code libraries that you might copy and put into your game that is okay because the copyright owner of that code library has made it available to you through what we call an open source license. That means they still own the copyright for it, but they are granting anybody who wants to use it a license to use it. That said, you have to be very careful that you are only using code or art or audio that has specific open source license provisions. Ab mentioned a Creative Commons copyright license, which is a type of open source license. They're allowing you to use their copyrighted works. But Creative Commons licenses have certain restrictions. They can say you can use this for commercial usage, which means you can make money off of it. Or they might say this cannot be used commercially. What they're saying is you can use this, in a classroom. You can use this to, for your own creative things. You put it in a scrapbook or a book that you're using for your family, but you cannot go and make money off of my content. And so there are some Creative Commons licenses or open source licenses that do not allow for commercial usage. So you want to make sure that it allows for commercial usage if you're going to make money off of it. And then if it does allow for commercial usage, they might say you can use it commercially if you provide attribution, which means you have to make sure that you are attributing the copyright owner in the end product. So if you use a library that requires attribution, your code needs to say, and you have to provide, disclaimers or disclosures somewhere that say, we are using code developed by so-and-so or by so-and-so company. That is an attribution that you're required under their open source license. Some of them don't care. They just say, hey, I own this, but anybody can use it for whatever purposes. I don't care. That is the best, the most flexible open source license that you can get. The ones that you want to watch out for are what I call a viral open source license. What that means is that if you include one of these viral open source code libraries or art in your product, that license says you can use it commercially, whatever you want, you don't have to pay us, but we want you to then make all of your code open source. So you include this viral open source copyrighted content in your bigger, product, all of your product then has to become open source, free for the taking, whatever. So that is a problem. You got to avoid those. Pay attention. There are so many open source licenses out there that it's hard for me to say these are the ones that work, these are the ones that don't work. If you're talking about code libraries, the ones that are universally known to be good open source licenses there's the Apache license. There is I'm trying to think. That's the MIT license and the Apache license are both the most commonly ones where you can incorporate any code library that is licensed under MIT or Apache, and you won't have any problems. You don't have to attribute, you don't have to pay, you don't have to make everything else open source. The ones that are universally kind of shied away from in terms of you don't want to incorporate this because it's a viral open source license is the GPL and the LGPL. General public license and lesser general public license is what it stands for, but they require you to make your entire product open source. So avoid that.
So a lot of these things I didn't know, and this is super fascinating. So I think this is really applicable to many of you developers. It's just looking at, when you go to look at that open source code, is just kind of looking through these different parameters Dan is setting out right now, and I think that'll help you understand. And there's a couple comments that are being made in legal, so I'm just going to pull that up. So if you can, throw it in the chat, just because we're in it now. But let's see.
I think this is the one that Ab put in.
This is the one that Ab put in.
Yeah.
So what happens in the event someone grants you permission to use something, but they didn't have the right? They didn't have the right to grant that permission, i.e., buy an asset that gives you the rights to use something. Gotcha. Dan, yeah, that's an interesting.
Yeah, so you could be liable. If you incorporate art, you paid somebody a license for that art, but that person didn't have the rights to license you the right to use, the original owner can come after you. They'll sue you for copyright infringement. Now, you can sue the person that you paid a license or got a license from and say, hey, I'm liable to this other person. You said you told me I could use it. I'm suing you. Now, if you didn't pay them anything, what can you sue them for? I don't know. You might be able to sue them for the damages, but I wouldn't. I would try to make sure that you are only licensing things that from people that you know own the right to license it. So something about that. Stack Overflow. Yeah, you got to make sure that anybody on Stack Overflow who's making code libraries available, they're going to be making them available through an open source license. You just got to make sure that the license that they're using is not viral and it allows for it. And you can Google pretty easily, like, hey, open source licenses, is this good or is it bad? And there's going to be a lot of conversation that you'll be able to pull up. But art is a big one. There are what I call IP trolls, which are companies that exist solely to collect fees and legal fees and from threatening to sue people who used art without a copyright license. And so if you put up on like your website a picture, there are web crawlers that just are going through the web every day looking at pictures and comparing them against picture libraries that are copyrighted. And then it's usually a law firm in connection with like a web crawler that the law firm will then just send an automated letter to you that says, you have violated my client's copyright by putting this picture on your website. They own that picture, and they do. But you thought that this was open source, you thought it was Creative Commons, whatever, you copied it off of a Google Images search and pasted it in your in your website, or you used some artwork from, again, Google image search. Google image isn't checking if something is open source. It's just showing you images that you search for, and you put that in your code, and somebody finds that out, they can sue you. And you got to be very careful with art, photography, video, and audio that you have a license to it, because IP trolls, there's so many of them out there. They've got it down to an automation where they don't even have to do anything. They just find out that you used that artwork. They send you a letter, and you have to pay them to make it go away, or else they'll sue you. And you do have to pay them, or else they will sue you. Like, it hurts. So be very careful. In terms of what you are creating, let's say you want to copy the game idea that somebody else has for your indie game. Can you do that? Yes, like a game concept or idea is not copyrighted. And I'll give an easier example of this. Board games. Monopoly cannot copyright the idea of a board where you go around and buy properties and pass jail and pass go. With hotels and houses, like somebody could create that game identical to Monopoly, as long as they are not using Monopoly's artwork, because their Monopoly's art is copyrighted. As long as they're not using their instruction manual and the wording of their instructions, because that is written, the instructions are copyrighted. So if you write up an entirely different and unique set of instructions that's worded differently but conveys the exact same type of instructions and game concept, but you don't copy the art, you can duplicate that game. You can't use Monopoly. That is a trademark. So that's a type of IP that we didn't talk about. And if you are referencing another game's name, and they haven't told you that you can, that is where you're not going to violate their copyright, but you might violate their trademark. They have trademarked their name and their brand. And so you can't use somebody else's brand without licensing it. So that AB, if you're going to be referencing, FTL or some other big popular game, and it's a very similar game design, you can't reference that game name without them authorizing you to. You can say, this is a roguelike or a rogue, light or whatever. That is not copyrighted or trademarked. It's a type of game. But you can't reference a specific game name without them authorizing you to or giving you a license to use their trademark, or else you're at risk.
If you can't tell, Dan is a bona fide gamer as well. But but basically, just my question on that then, if we're talking about IP, and I know there's a question earlier from JW Duth. Basically, if you come up with an idea, and it's kind of like this idea, it's a gameplay idea, or it does this or that, it sounds like that is something you can't protect. And it's the same thing, like you can go make a game with the same gameplay as FTL, as long as you don't use the art, you don't use the music, you don't use the messaging, right?
That's exactly right. Like, you could have spaceships with aliens and, you're moving across a galaxy. That FTL can't protect that. There is nothing in the United States that protects game concepts. It's just as long that code, the art, the music, that is copyright protected. So that's IP. Again, very important to you guys. You want to be very careful about it, very, very cautious about it. The other aspect here, Taco, the terms of service in Stack Overflow, again, you got to just make sure that you understand what the terms of service allow for. I'm not a developer, and so I know what Stack Overflow is. I don't know how you get access to those libraries, or if you have to agree to, terms of service, you have to give attribution. Again, I don't know that. I do know about the legal aspects of open source. So, all right. The other piece I want to go ahead.
And we just want to finish this up. Throw any last questions you guys have. And Rug, I know you had some of these questions So we want to address these because you put them in the legal. So we'll address these just right after he addresses this.
Actually, this is actually what I wanted to talk about. So terms of service, privacy policy, end user license agreement. This is the legal relationship between you and the end user. This is the contract that binds how the end user uses your product. And that is where you want to make sure you talk about, hey, we are giving you a license to use our game, our app, our software, our art, but we aren't allowing you to do it commercially. We own that. And this is where you declare your ownership of your copyrighted works. And you license the end user to use it for a specific purpose, which is to play your game. And so that is all in your terms of service or end user license agreement. These are all kind of that click through, what we call a click through agreement, because you put it on, the login or the account creation, and you say, when you create your account, you agree to our terms of service, end user license agreement, privacy policy. That is what governs the relationship, and that is also what you want to make sure allows you to be compliant with privacy laws. We haven't talked about privacy. That in and of itself could be a long discussion. You can't store personal information unless you are compliant with privacy laws. GDPR, Canada has its own one called PIPEDA. California has one called CCPA. You have to be aware of these if you're going to be storing any data from the user. And primarily, personal information from the user is what is protected. Their usage history, not that big of a deal. You want to declare that you're tracking that, but it's not that heavily regulated. Personal information like their contact and their email, and what you do with that, very heavily regulated.
What if you're tracking gameplay, for example, and you anonymize it, right? If everything's anonymized, you are tracking it to see if people are cheating, stuff like that. How does that play into all this?
Totally fine, as long as it is in the click-through agreements. The terms of service and the privacy policy need to declare that. We are tracking your usage. We're going to anonymize it and aggregate it and keep track of this. We're also going to make sure you track your usage and make sure you're not cheating. And if you do cheat, that's a violation of our terms of service. Usually terms of service will say you cannot use the code for these things. And that includes whatever type of, hacking, cheating, botting, whatever that you want to prohibit on your game. You can have that, you put that in your terms of service so that it is a violation and you can sue them to stop it if it's declared there. So that's all part of that. Very important to do it right. That is, again, legal things that you need to do. And a lot of those are more customized. They're not templatized per se. And so that's one of the trickier aspects of launching a game.
And so let's say Steam, for example, has a built-in EULA in some way, right? It kind of has a standardized format. So I think to Rug, he's asking, at what point do you need a privacy policy, terms of service, EULA? If your game is just a game that's using Steam's already built-in account system, you don't have your own personal EULA, you're not tracking any personal data, do you need any kind of customized templating or customized documentation?
Great question. I actually, despite the fact that I am on Steam somewhat regularly, have never actually pulled up their EULA. And so I don't know how well it protects the game owner and the game manufacturer. I'm going to look at that. So I have to take a buy on that and say, I don't know the answer to that question with respect to Steam, iOS, any of those, those platforms. I have to look at that. Good question, though. You probably should know that. As a game developer, you probably want to make sure that you understand is Steam's... I imagine Steam, it's in their best interest to protect the game developer because...
I believe it does. I've looked at it.
But, again, I haven't ever read it, so I can't say.
No. Yeah, so again, I don't know but when do you need an EULA? I think based off of kind of Dan's response,
as soon as you're delivering a game to anybody, you want to have that in place.
And so it's really dependent. If you have something that is unique or custom, I think would be the assumption, something that is in your game that Steam doesn't protect, that may be when you need maybe your own. And then when it comes to crowdsourcing, you're talking about translations, translator. I think that feeds into the conversation earlier. If any kind of work that's being done, right?
Yep. Even translation work, you want to have a contractor agreement to make sure that the work that they do for you, the translation work, is owned by you.
Yeah, and again, the last question. There's a balance between player data tracking. I think we kind of already addressed this. It's what is that balance? It's more of a question of, does it violate your personal information versus, is this being anonymized? I think there's that nuance. I don't know if you want to address anything last on that.
Yeah, if you do have like a built-in chat or voice log, you want to make sure that your terms of service accounts for that. And just to state like, hey, you are responsible for anything that you state or share on the chat or the voice log. You're liable if you share anything that is illegal. You're liable if you share anything that infringes somebody else's right, not us. And by the way, we are going to track all of this. FYI, we are declaring to you that we are tracking chat and voice logs. And so it's okay for you to do that as long as you do it the right way. And so that is where your terms of service and your privacy policy being drafted to account for that usage is very important.
I know. So is there anything else? I just was going to address some of these questions. Is there anything else you want to talk about before I just finish with a few questions?
No.
Okay, so I know there's a question from Ab who said, so you were kind of re-popping this up. I realized the artwork didn't pace. So the idea of, I think maybe the question broadly is changing other people's work to make it your own. I think would be my assumption is what's being asked. I don't know if that's kind of what you got, but.
I mean, I can't look at the artwork and just say, hey, that you're good to go. But if somebody says you can't change the artwork, changing the opacity might, and the angle of the brush, might be a change to the artwork. There's risk for you to change that artwork in any way if they say you cannot change.
Yeah, I think what's the as they always say, like all code is stolen code. All art is, it's all mimic. It's all some kind of copy. So I think like anything, it's what it define copy. AI, the reason why people are pissed off by AI is it's straight up copying. It's taking their work and monetizing it in some capacity. Yep. I think there's nuance in the question.
There is, for sure.
But
it's tricky.
Yeah.
It's tricky. I don't like to be the kind of guy that's like, hey, you cannot do this. So you've got a brush that you're changing. I guess I don't understand the Creative Commons on the brush aspect of it. If you're using a brush and they're letting you use the brush.
I've done a lot of design over the years. So like I've used a lot of other people's designs, and then I'll take that design as a base and then create something else from it. If it's not recognizable, I think it would be like, kind of what you're saying. If it's not recognizable, there's no way that they're going to know you used it as a base. If it's obvious that you took it, used it, and it was not allowed, I think that's the nuance, right? Like if you use it as a base, then create something else that isn't recognizable, isn't obvious that you took their work. I think again, the nature of art is you look at somebody else's art, you say, "Ooh, this is cool. I'd like to do these things, change these things," and it becomes its own piece of art. So I think the nuance, that's the nature of creativity. So I think that would be, I don't know what you have thoughts on that, but why don't we just jump to Taqua's question, because I know we're out of time. So I think the only way we can form a legal entity, he's talking about in Ukraine, by forming a company in another country. And so I don't know, Dan. I don't know. Again, I don't know Ukraine, and that's, I think, the complexity here.
You can form a U.S. entity without being a resident. The trickiest part is getting an EIN in the United States without having a U.S. taxpayer listed on your EIN application. EIN is your U.S. tax ID for your business. So you could form a Delaware LLC, a Wyoming LLC, a Utah LLC without being a legal resident in any of those states just fine. You will need to pay what we call a registered agent to be your address in the state. That's something that we can help with. The trickiest part, like I said, You can get the entity formed and sign contracts with that entity. Getting an EIN is going to be your hardest thing, and it's not impossible. It just takes time. You have to do a specific method where you call into the IRS to get the EIN, and it takes 6 weeks, up to 6 weeks. It can be very slow, but you can definitely do it, Taco. If you want to form an entity in the U.S. and have that entity sign all of your contracts, works just great. You're protected under U.S. law. Whether your country of residence will enforce that, up to your country, the judicial system in your country to decide that. But with respect to, if you wanted to come to Delaware and sue somebody who breached a contract, you could do that, or pay somebody in Delaware to sue somebody for breach of contract with that Delaware entity. I'm using Delaware because Delaware is the most commonly used state for entity formations. It's a good state. It's not necessarily the best state. It's not the cheapest state, but it works. It's most heavily used. And so that's why I use the state of Delaware in the United States.
Yeah, I have an entity in Delaware. I have an entity in a different state. I have an entity in another state. I have a few different ones. Okay, let's see. Scroll back down. Okay, last question from Rog, and then we can just kind of finish up any last, if you want to soapbox it for a sec. But seems like privacy policy terms of service require a point of contact, such as physical address, real name. Yeah, usually you need to have a phone number, right? There's certain things. I want to separate my real identity from the games due to issues with doxing threats, etc. Okay.
So privacy policy primarily is the one that requires a contact. Basically, if somebody says, I want you to delete my private information, they have to have a contact that they can connect to request that. That's what part of the compliance with privacy laws is, that anybody can get their information deleted upon request. That is the contact point that is required. Does it have to be you? Does it have to be your address? Does it have to be your email? No. There just has to be a contact point. And now there are companies out there that you can pay for to do your privacy policy management. And I believe that they include a contact point that you can use them. You could just put support at devco.com, whatever your, it doesn't have to be your name. It can be a kind of a generic email and contact. And you just say contact support at, contact our support team, the following information, and you put a phone number in there. Again, I can't remember. I'm not a privacy policy regulatory attorney. I can't remember if they require a phone number. They might.
I think we did. So for our software company, at least because we were dealing with certain types of privacy when it came to FERPA, so we had to require it. I don't know if that's the only reason why I said phone number. I just remember we had to have it based off of our own type of company. But that's my phone.
So, yeah, I don't think you individually have to be the contact point. You just have to have a contact, a place where they can contact to request that you delete their private information. So, does that work? I think that should be that.
I think that's that. I think this cut out our video over here. There we go. Okay. Well, thanks, guys. This will be on Patreon. We're actually going to use footage from this for multiple things. We hope to have Dan back on, not just today, but times in the future.
Yeah, I'd love to be back.
Dan's going to be playing a pivotal role in helping us do a lot of things we want to do going forward in the future. So more Dan. We like Dan. So appreciate you guys. Good questions, and we look forward to do more of this with Dan. So
thanks, everybody.
We'll see you. Let's stop here.